welcome everybody to the 30th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman. Very different format today because it's like the biggest day in the history of TCPA world, at least last Friday was. We're recording today on Monday, January 27th, 2025, the day that the one-to-one rule was supposed to go in effect, but it didn't. And we're going to talk all about why that is. An incredible last-minute drama, so much excitement, and it was really an incredible day on Friday, and TCPA world is just blowing up right now. But before we dive into all that, let's introduce who we have. Let's start with the lady in the pink.
Hello, folks. Queenie here, Troutman Amin, partner at Troutman Amin. Excited to be here.
And over there in the, what is that, teal?
Yes, it's Jennifer Cabrera. I'm from South Florida, although it's not feeling very Florida-like right now, but things are definitely heating up in the TCPA space, so we'll take it.
Also known as the Countess. Fantastic to have you. So what we've done, folks, is we've just gone like top of the house. We've got the head of compliance over here with Pooja. You've got, of course, the head of litigation at Troutman Amin with the czar, and you've got Jen, who's basically handling the outreach FCC connection, kind of the most hands-on person out there right now and dealing with the commission. So we all got together. I know this is a very unusual format. We're not in our studio. We don't have a three-clamor format. We're just doing it as a webinar. I thought about throwing a webinar, but then you guys have to go and like register for that. Why are we going to do that? Let's just get together, put it on the YouTube channel, make it a Deserve to Win episode. I promise the rest of the Deserve to Wins are going to go back to formula. This will be the only one where we kind of break formula and do it a little bit differently. And it's just because we wanted to get these thoughts out to you as quickly as we can. All right, so let's level set real quick. What happened? As you all know, the FCC's, the drama has been going on for over a year now. FCC was going to modify the definition of express written consent and require that the consumer had to provide consent to one identified seller at a time, and that consent had to be logically and topically related to the transaction that led to the consent. This would have been a massive change for lead generation. Today, of course, the industry operates largely using hyperlinks, which may or may not be enforceable. I think we're going to find out more about that. So one of the things we're going to talk about here today. They've got one set of practices that they've been doing for 10 or 15 years that are coming under incredible scrutiny right now from the courts, but it is just the way that they've always done things, and one-to-one was going to be a marked departure from that. Just a big change. Lots of kind of approaches that people were taking to challenge this ruling. Three big ones. One, of course, was IMC, the Insurance Marketing Coalition. Going to be talking about them a lot today. They took a challenge to the 11th Circuit Court of Appeals, which I characterized as a long shot challenge. And it was, but sometimes long shots pay off, and this one did. We're going to talk about that. Second, Reach went forward with a couple of different moves. One, of course, part of the SBA, Small Business Administration, public notice proceeding with a comment to try to get the rule narrowed down, and then later an emergency petition in light of Trump's executive order trying to get that commission to stay the ruling, which looks like it found pay dirt. We're going to talk about that. And then last was something called the Online Lenders Alliance, which did a really good job, had kind of a slow-moving effort that really could have, and we don't know, but maybe behind the scenes did move the needle with the commission to try to get it stayed and ultimately to get the rule modified. But despite all of these different efforts, right, you can think about it in a football analogy. You had one person kind of running a 20-yard curl, one person kind of doing a little, post route, and then of course the home run. I guess that would be the post route all the way to the end zone, which was IMC, right? So we had three different organizations coming at this from three different ways, and a couple of them actually found pay dirt. Let's talk real quick before we get to the analysis of the 11th Circuit Court of Appeal and the ruling and what actually has. Really, the big news, right, is the IMC ruling out of the 11th Circuit. But let's talk real quick about some of these other efforts. OLA, I've kind of teed up, right? They had a petition for reconsideration looking at the impact on small businesses, asking that commission, hey, pause this whole thing, rethink about what you're doing, and let's make some modifications. Now, this was built on the backbone of the efforts of Reach that came previous, that were looking, again, working with the SBA, trying to make these comments, try to get the commission to understand that this new one-to-one rule, even though directionally Reach actually supports the rule, right? Because it is important that we stop unwanted robocalls and that we give lead generators clear standards, clear protocols, right? Rules of the road that they have to follow. So one-to-one directionally was a step in the correct direction. The issue was the way that it was written, There was a lot of problems with it. And Reach had the comments that were going forward as part of the small business effort. So that was out there. But this last minute effort, Jen, I want you to kind of talk about it. We had kind of a last minute effort with an emergency petition to try to stay the ruling. Can you just kind of, I'll let you tee this up. Like, what exactly happened last week, starting on Monday, to try to get things slowed down over there at the commission?
Yeah, sure. So Monday we had inauguration. So President Trump took over, took the oath for president, and with that, a flurry of just executive orders came in that he said he would sign, and he did. And one of those was requesting an order for requesting agencies to stay any decisions that were not finalized, and to allow for a comment period so that the new administration could determine whether or not the previous rules that could have gone into effect were in line with the new administration's policies. And this is not something new. This is something that happens when administrations change. They call it, midnight making. At the end of the previous administration's time, they just kind of push as many rules and regs as they can. And now, while we've had this one-to-one we were looking at it over a year, it is something that's common. And so President Trump signed the executive order, and as a result, Reach filed a petition to stay, saying, in light of President Trump's order, we should take some stay for this January 27th, 2025 effective date, and get comments and see whether or not, is this something that we should be moving forward. So we did file that on Monday night, right after President Trump signed that executive order.
Yeah, so it was a great effort. Now, the thing is, the executive order only stayed action by executive agencies, and the FCC. I mean, you could make an argument they're an executive agency. You can make an argument that they're a legislative agency, but generally speaking, they're viewed as an independent agency. So this was not likely to find pay dirt on all fours, meaning I did not at any point expect, I don't think anybody did, the commission would come out and say, oh, yeah, we're an executive agency, so we have to honor President Trump's directive. Rather, what this is a vehicle to commence consideration at the commission that would lead to exactly what they did, which is sua sponte review, right? And that's something that the commission has inherent authority to do. And if you look back at my webinars from last week, you'll see I was talking about this inherent authority, right? That's really the angle that we were going for. But we used the executive order as that push, right? That thing that would kind of get things moving in an above the board fashion. And we were hoping that we were going to draw some opposition to let us then tease out a little bit more, right, some of the substantive issues. And guess what happened? Jen?
We received an opposition from NCLC and other privacy groups, and the opposition basically stated that the rule had gone through the process of comments, and all comments were provided, and regardless of the comments, the one-to-one consent rule, what was needed, it was required to end this lead generation quote unquote loophole and ensure that consumers were not inundated with this robocall pandemic. And so and they cited to some authority as well, but it wasn't directly on point on the issue that we had here, and the bigger issue. So we had an opportunity to reply, and we replied, yeah. And we noted the fact that according to the APA, right, the FCC could determine that they did not want to move forward at this time, and so we filed a reply on Thursday. Right after. It was a very eventful week. Everything, it was just one thing right after the other, but the biggest day was Friday, but I'll let you get to that.
Well, so they come out, and the primary argument for the NCLC, right? They throw all this policy junk in there, like, who cares? Like, you're missing the point, NCLC. Their primary argument, which is the perfect vehicle, was, hey, look, you can't do this, FCC. You don't have authority. I was like, oh, perfect. There it is, right? That's exactly the move that we wanted. So we come back and we're like, oh, hey, there's these sections under the APA. I'm not sure if you've ever noticed these, FCC. They kind of give you inherent authority to do some stuff. So I don't know, we're just throwing it out there. And of course, that's exactly what they picked up. Now, Pooja and I flew out actually Thursday night to try to have some last minute kind of emergency meetings with those guys. But we heard back from Carr's office, like, hey, we got it. No worries. And sure enough, right? And there was a nail biter. Friday was a nail biter, right? What's going to happen? But of course, look, winners win, right? right? Winners win. And they came out with a beautiful order. It's succinct, it's sua sponte. They, say, hey, Reach, we're not going to grant your petition because that would require them to be an executive agency. But they did exactly what we wanted them to do and exactly on the grounds that we were hoping they would do it. So it was fantastic. It was beautiful. It was chef's kiss. It was exactly kind of what, the real pros, if I dare say, would want to see accomplished and how it's done. And it was beautiful. It was great. The problem is the ruling came out at 4:30, and at 4:34, the 11th Circuit Court of Appeal strikes down the entire thing. So all of that hard work, I mean, essentially, not just that hard work, really, all the hard work of Reach, but beyond Reach for over a year working on this, honestly, all the hard work of all the lead generation companies and all the lead buyers that were kind of looking for the new paradigm all got washed away. And this is it's a massive piece of the story that we're going to talk about, not today, but in kind of future episodes and on TCPA World, is just how much hard work went into something that suddenly just got stripped away and how damaging that actually is for many companies. Now, luckily, as Pooja's going to tell you in a bit, I think there's value still, a lot of value to one-to-one. And so we're going to talk right now about the ruling. But before we get to the ruling, we just have to mention Lending Tree. I mean, can you imagine this? Just imagine this for a second. You are, and I hear this came from the CEO. Maybe it didn't. I haven't seen the full email, but I hear it came from the CEO. If it didn't come from the CEO, then forget this part. But my understanding is the CEO of a publicly traded company on the night of a massive win for industry decided to send an email to, and again, I haven't seen the email distribution list, but I've been told they went to like all their partners, all their lead buyers, and sent them an email that basically said, look what we, Lending Tree, did. As if they were the ones that came up with all of this and did it all themselves, like glory hogging to the nth degree, which, by the way, nobody likes. Nobody likes that. Nobody even likes it when I do it. Even when I actually deserve to take credit, people don't like it. Nobody wants to hear that from anybody. But especially not from a company that really, if they had anything to do with it, it was like, oh, they put some money behind it. Oh, okay. Way to go, guys. Great effort. And not only that, but this is the part that just boggles my mind. The CEO of a publicly traded company, apparently. Again, I'm saying apparently because I haven't seen the email and made sure it came from the CEO. So if it didn't, no defamation here. I'm saying, this is the information that I have, and I believe it to be true. The CEO of a publicly traded company sends an email specifically mentioning Eric Troutman on the day of a massive victory and specifically mentioning Reach. That's incredible. Isn't that just an incredible thing? Like, at what point did I become so powerful that CEOs of publicly traded companies on like the biggest day of maybe their year, I mean, their stock is up 17% right now as I speak, right? Friday was a massive day for Lending Tree. And they thought they would just take a break and point out to me real quick, which I just love. Obviously, I appreciate the attention, guys. But the most uninformed, ill-conceived message, which was Troutman had nothing to do with this. Preposterous. I mean, it's, first of all, nobody believes that, not even for a second, Lending Tree. The fact that you would even waste your time doing that, it's just, as Pooja said, so remarkably petty and silly and tone deaf, right? I mean, this was a moment when IMC and Reach, we were like on LinkedIn, like high-fiving each other. I was so proud of those guys. And we're going to talk about what they actually accomplished here. And it really is remarkable. And they deserve so much praise. And they were very gracious. They were like, hey, look, Reach, thanks for your efforts. And we were all kind of like, dude, it's the greatest day of the year. So we did so well. We worked together. It demonstrated that we can work together, that, different approaches, different strokes for different folks. It's a good thing. There's room for everybody. Big tent. And then Lending Tree just comes out and was like, nah, it was all us. And, Troutman, he had nothing to do with it. IMC, maybe, whatever, but it really was us. I mean, I'm paraphrasing. You guys should read the email. It's on tcpaworld.com. Speaking of which, everybody is reading tcpaworld.com right now. Holy smokes. Friday, and Queenie's over here, like she hasn't had a chance to talk yet. You're going to get to talk, Queenie, I promise. Friday was the second busiest day in TCPA World's history, which is really good because a Friday, people generally don't read blogs on a Friday, but everyone read this thing. We had like tens of thousands of views. It was crazy how many people showed up. We're going to have the biggest week in the blog's history, and we're on pace for the biggest month in the blog's history. And in terms of people viewing daily, we're up over 100% from 2024, and that was up over 50% from 2023, and that was up like 50% for 2022. I mean, it's like, this is a rocket ship, guys. It is a rocket ship. everybody wants to read tcpaworld.com because it's the only place that really breaks the news, gives it to you straight. It's the place where people go because they know they can trust the information they receive, which was a big thing that I was talking with Mariah Gates about last week. She's the CEO of Accelerated Automation. And she was saying, man, like we've got tens of thousands of agents. We've got all these people that are looking for real information and guidance, and they got nowhere to go because, man, you look at these YouTube videos, it is clown city, man. It is terrifying what people are out there saying. They're almost always wrong when they're trying to break down analysis, and they'll actually say things aggressively against people's best interests, saying, oh, the TCPA, it's no big deal. Oh, you know, who cares? It's $500 if you get sued. What's the big deal? I mean, it's nuts, the stuff people say. So as we always say, look for the lion. So many of you have found tcpaworld.com and are so gracious and kind, so thankful and grateful. I get so many emails every day from people thanking me. I love that. Thank you. Keep those coming, by the way. I do like them. But okay, so let's actually get now to the ruling. Massive, massive change from the 11th Circuit Court of Appeals. And I'm going to tell you, I am not sure that the analytic framework that the 11th Circuit applied is the correct one. But it doesn't matter because it's their framework and they're the judges and nobody else. And they've come to their ruling and that's how it's going to be. But here's what they did, right? They basically said, look, the FCC has the ability to implement the TCPA. And that means it has to make some helpful rules that will reasonably define what, for instance, express consent means. But what they cannot do is alter the language of the statute or make a rule that is different than what the statute says, which, by the way, I agree with. The problem is that the statute doesn't really say anything. All the statute says is express consent, and it doesn't define express consent. Now, conceptually, that means, wait for it, the FCC gets to define express consent. At least that's the way it's always been. And when the IMC filed its petition long ago, back in originally December of 2023, when I said, dude, this has basically no chance, the reason is that at that time, courts still had to defer to agency determinations, and the FCC had the ability to reasonably define express consent as it saw fit. And after, ironically, Lending Tree screwed it up. When you talk about ill-advised, you want to talk about bad decision-making. An ex parte between the draft. You guys remember this? There was the draft 1-to-1 ruling, and there was a final vote, and Lending Tree comes in with an ex parte in between that time frame. Holy God. And that just pointed out a bunch of little maybe ticky-tack mistakes that the FCC had made that allowed the FCC to then fix those mistakes. Do you guys remember this? It was nuts. I mean, we're talking about ill-advised. We're talking about a bad decision. Holy smokes. And of course, they fixed it up, right? And so now when IMC takes this petition, under the existing law, the framework of the law at that time in December 2023, man, this did not look like it was going anywhere, right? But a bunch of things changed. It was remarkable. Like a bunch of things broke in favor of IMC during the course of the appeal. Of course, one of them is that Loper Bright, the Supreme Court came out and struck down the entire concept of Chevron deference. What a huge, massive change. At the same time, when they got their panel, they actually, the 11th Circuit, so the way it works is the Court of Appeal will assign 3 different judges to a case to make the decision on the appeal. They were assigned 3 Trump judges, that is, judges appointed by Trump. And one of them, a judge named Judge Luck, really perceived as a procedural stickler. I mean, like probably the best possible draw, at least from my understanding, in terms of who was on that panel. So just an incredible result. And then a bunch of cover fire because, of course, President Trump wins both the election and Republicans take both the House and the Senate. And now, I mean, it is pretty clear, right, that this court is feeling very empowered. They don't have to defer to anybody. They've got a whole new administration. They've got one of the stickiest stickler judges out there procedurally. And all of a sudden, this thing that had a 5% chance, I did a revised, after oral argument took place in December, I did a revised analysis. I was like, guys, I got to tell you, this thing's got like north of 50% chance all of a sudden of going away because everything broke in their favor. And that's exactly what ended up happening. So the 11th Circuit Court of Appeals looks at the TCPA and says, hey, look, express consent is not defined. But we, as a court, we've defined it before. We've defined it to mean consent that is clearly and unmistakably stated. So therefore, that's what express written consent means. It has to be consent that is clearly and unmistakably stated. But FCC, that's not what you said. What you said was that consent had to be provided to one seller at a time. But that's not what we've said. So your construction is wrong. You said it has to be logically and topically related, but that's not what the courts have said. So your construction is wrong. Now, I'm paraphrasing a little bit, but the essence of it is really very close to that in terms of like the pithiness of the analysis. I'm not picking on the 11th Circuit. I'm just saying this was a very kind of streamlined, elegant, to be polite, kind of analysis that basically framed these issues in a single question, which is, are there ways to provide express consent under the court's law that are not allowed under the FCC's interpretation? Yes or no? And the conclusion is, of course, yeah. The express consent definition adopted by the courts is broader than the express consent limitations adopted by the FCC. And as I point out in my blog, to define is to limit. So if the FCC is providing any definition of express consent, that definition is necessarily going to limit some other forms of consent that would have otherwise been permitted under some different, broader definition. Any definition is going to be somewhat limiting. Yet the court's analysis was essentially any limitation, i.e. any definition, is going to be too much. An abuse of power, an excess of power. So essentially what the court has done is created a paradigm where agencies cannot issue definitions unless they parrot or paraphrase what the courts have found. And it's really incredibly fascinating. And I want to say wrong, except that it might not be, because we're living in a whole new world. Remember, I told you November 5th was not an election. That was a revolution. And post-revolution, we don't know what the world looks like anymore, right? So I can tell you what the legal paradigm was before. The legal paradigm was before that agencies have the ability to act. They can reasonably define words. That's what they're allowed to do. After IMC, this new ruling, I don't know, right? Now, will other courts follow the IMC on the breadth of its analysis in terms of what these agencies are allowed to do? Don't know. I want to say no. I want to say probably not, but it's tough to say because, again, we are in a whole new legal paradigm. But what we do know is that the 11th Circuit Court of Appeal on this analysis has determined that the FCC overstepped and has struck down one-to-one consent as a result, period, full stop. Because this was a Hobbs Act appeal, a Hobbs Act challenge, what that means is the 11th Circuit's ruling is binding across the country. Normally it wouldn't be. Normally it would only be binding in the 11th Circuit footprint, but because of the Hobbs Act nature of the appeal, the 11th Circuit has jurisdiction over all the courts to make this determination and has determined that the express consent ruling of the FCC that it has to be provided one-to-one and that has to be logically and topically related, that entire component of the ruling is gone. It is struck down. It is dust. It is vapor. Pooja, where does that leave us?
Well, that leads us back to Friday and everything that came before Friday, right? So that means all that fraudulent data, all that illegal data that's, really what's driving litigation current present day, right? That's why we have a litigation practice here at Troutman Amin, right? As well as a compliance practice. All that we've been preaching for years on years, all the webinars we've done are still in existence. It is still good guidance and it is best practices and it is the law. So everything that we've been teaching you, from not using dark patterns, not buying fraudulent traffic, from knowing who your lead vendors are, from your contract terms, making sure you have indemnity, and even something as, that seems a little bit smaller, but a lot of people forget, is making sure that the seller is listed on your Troutman 9 consent forms now, right? Those will continue, those standards are going to continue to drive litigation. So those folks who are preaching on LinkedIn that the word compliance is no longer a thing at conferences, my goodness, you are a complete fool. Because the reason we've been speaking all these years on compliance is because even the current state of law, right, it has been driving enormous amount of litigation, right, and massive TCPA class action settlements. And so, the law is not going away. In fact, it is remaining exactly how it was on Friday or even yesterday. So, you have to continue to keep that in mind, right? Though the one-to-one consent portion, the logically topically related portions are no longer going to be the law moving forward, guess what? Still the law, right? Plaintiff's attorneys are still going to look at your web form disclosures to see if they're conspicuous and clear to the consumers. Plaintiff's attorneys are still going to look at the disclosure form to see if the seller is actually named in the form. Sure, hyperlinks can continue. Courts are still, and plaintiff's attorneys are still going to look at whether you have 50,000 sellers listed on that page or you have 500 or even 5, because those are the things that the courts have continued to look at, and they're going to, I guarantee the plaintiff's attorneys are now going to hone down on those Troutman 9 requirements even more so than they were. And more importantly, all this fraudulent data that, you know, is coming from overseas or even within the states currently, that data, you know, you better have your consent records, and you better vouch for where those consent records are coming from, right? If you're working with a third-party lead vendor and they're working with 60 different downstream parties, you ought to know about those 60 downstream parties. Otherwise, the TCPA class actions are still there. They're still prominent. They've been there since 1991. My goodness. And just read tcpaworld.com, right? We announce the big settlements every single day. Those are a result of the data and the leads that have been floating around for many, many years. And the 4-year statute of limitation doesn't go away, right? The ability to sue a person personally doesn't go away. The $500 up to $1,500 per call or text, that doesn't go away, right? So, you know, all the TCPA compliance that you have learned over the years, you know, through Troutman Amin and through TCPAworld.com still isn't existent. And it is more important, I think, now ever than before, because I can see a lot of lead generators who are not educated in compliance, taking advantage of the 11th Circuit opinion, because now they think they can do whatever they want and continue to sell age data, right? Sell traffic that isn't consented or is not backed up by, you know, reputable consent sources, right? A lot of another thing we're seeing is that these consent records are even becoming fraudulent, right? So keeping an eye out on who is capturing your consent, right? Making sure that you have those records in your possession, not only to defend your case, but you probably want it even beforehand to understand what the website disclosure looks like. So, you know, I think the biggest concern, Eric, for me right now is the fact that lead generators who have already been so problematic for my lead buyer clients are going to continue to take advantage of the law as it exists. And that scares me. It scares me really because we represent largely the lead buyers. And I think, honestly, reach becomes even more important now. Right? Having an organization where you have compliant lead sellers working with good buyers becomes increasingly more important now, because the lead buyers don't want to continue to handling these TCPA class actions, right, on behalf of bad acts by lead generators. So, I mean, it just doesn't change, right? The law is still there. Compliance is still important. You still have to vet your vendors, and you have to continue to do your due diligence.
Yeah, so it's fascinating. You said a few things there. First, you're not a complete fool if you don't want to hear about compliance at conferences, but unfortunately, you're going to have to, because compliance is just as important as it was on Friday. It's very, very important still, as Pooja was laying out. But IMC, you know, I want to put my arm around IMC. I think there's been too much of a fracture in the industry, and I think, look, as you just laid out, the big risk of the ruling, which is a great ruling, and I think you should be celebrated. But there is a downside. There is a risk, which is the bad actors out there, and there's so many of them. The bad actors who want to sell fraudulent data and abuse consumers and trick them with dark patterns now feel somehow like, oh, well, now we can do that. No, you can't. You can't. It was illegal before, and it's still illegal. But the problem also isn't just the lead sellers; it's the lead buyers, right? So many of these lead buyers that you know we've spoken to, you know, are just looking for volume, and that creates this marketplace for really, you know, call it gray, but really it's kind of very black in terms of, you know, are these legitimate leads or not? And people seem, you know, I'm not going to name names, but some folks seem perfectly comfortable buying leads that just aren't real or are highly susceptible to a finding of falsehood. Let's just say it that way. And the risk that this creates for organizations is just enormous. And I understand that in these organizations, the lead buyers, the market folks, the marketers, they just want to get, they're, I don't want to call them sleazy, but like some of these guys are just like, hey, look, we just want to be hitting people. We just need volumes. We can get our call centers revved up and we can get revenue. And at the end of the day, they just want to make some money for their company. And that's not a bad thing. Like, I get it, right? But, the in-house lawyers and compliance folks at these institutions need to be paying very close attention right now, because, in the next 6 months, the opportunity, I'm using that word in the pejorative sense, for people to take advantage of consumers and for lead generators and lead buyers to cooperate in a race to the bottom, which is what we saw from 2016 to about 2018 when you and I came into the industry, Pooja, and started pushing to try to clean it up. This race to the bottom mentality might return, and if it does, it's just going to make Anthony Peronic richer than he already is. It's just going to make the class action attorneys all that much more money. And the other thing that I think is very concerning about this particular narrative is that there's going to be the perception, and it might even be an accurate perception, that the new FTC, right, which was so aggressive during the telemarketing sweep back in 2023 and into 2024, is suddenly going to be neutered because now we've got a new administration and they're not going to do anything. And I don't know. I mean, that might actually be true. Right. So if you are a lead generator, you're a lead buyer, you might think, hey, look, the courts just struck down 1-1. The FTC isn't going to do anything. The new FCC is not going to come back with a new rule. So maybe we can just run free, man. Let the good times roll. And on the one hand, let the good times roll. Right. Like, I'm a proponent of all y'all going out there and making a bunch of money. But ultimately, the rules are still the rules. And I know we've got a patchwork out there in the courts, and it really does start to feel like a little bit of a crapshoot, right? We get sued. I don't know. Maybe we'll get a good Trump judge, just throw the whole thing out. Who knows? Maybe, now part of the analysis of the 11th Circuit suggested that other parts of the TCPA and the FCC's express consent rules might go away. Hey, maybe, we can get consent over the phone after all. Of course, no court's found that way, but hey, maybe we'll take a shot and maybe the court will rule in our favor. And that is kind of the mentality that a win like this, again, it's a good win. I support it. And I'm glad that IMC did what it did. But it does start to kind of lead to this, oh, hell, we'll take some shots because, yeah, maybe we'll pull it off sort of mentality. That's very dangerous. Again, if you're a fly-by-night, if you're a younger company, if you're an aggressive shop with 10 million in revenue and you're just trying to put as much money in your pocket as you can, making hay while the sun is shining, okay. But if you're a publicly traded brand, either as a seller or a buyer, you got to be smarter than that. You just have to be. Now, whether or not people are going to be smarter than that, Pooja, I don't know. Some other thoughts on that?
Well, I mean, you look at it this way, right? Folks, if you're a head of TCPA compliance with your organization, you need to understand that marketing folks and sales folks aren't incentivized to be compliant. They are incentivized to make profits and make sales, right? So when you look at it from that lens, right, their agenda now all of a sudden shifts back to Friday and before Friday, right? Which is up the ante, buy as much as leads as we can, make as many outbound calls as we can. And now, sure, Eric, we may get, favorable rulings throughout the court now, perhaps, and there's going to be a lot of lead buyers who are going to be willing to take that risk. I understand that, but for those buyers who have that mentality, and especially those who have been sued numerous times, litigation is not cheap. Right. I understand compliance can be a little bit costly. A lot of folks were preparing to the 1-to-1 consent. A lot of folks were hiring Troutman Amin to help them get compliant, and I respect that. But that compliance advice that we've been providing in preparation for 1-to-1 consent is still great advice, right? It's still going to keep you protected. However, litigation, it's expensive, right? And you can take those risks, but once you're in there, once you're sued, these are arguments that your outside counsel are going to have to make on your behalf. You can be tied up in litigation for years on years, and it's not cheap to fight within courts. So you got to keep that in mind, right? If that's going to be a cost of doing your business, that's fine. That's something you're going to have to incorporate into your strategies and your goals, keeping in mind that once you're sued, right? And it takes a little bit to get out. And I suspect, Eric, the Anthony Peronics of the world, Greenwalds of the world, I don't know that they're going to start settling these cases as quickly as they've been, right? They may want to challenge and bring these new arguments into court to see how the courts are going to react, right? I can suspect that they're going to start trying to figure out where the judges are lying within the districts.
That's right.
So, these settlements, go ahead.
And well, that's the problem, right? And that's why the plaintiffs' lawyers have always been so much smarter than the defense lawyers. The plaintiffs will bring the right cases in front of the right judges, find the right judges, find the right opposing counsel, and make their case law, just like they've done for the last 10 years. So, from a certain perspective, God, from a certain perspective, 1-to-1 was good for lead generators. I mean, it was bad for a lot of other reasons. It was going to cost a lot of jobs. It was really poorly worded, and it needed to be changed. But the concept of 1-to-1 was so good for lead buyers. It was going to keep them out of so much trouble because we were going to have really actually motivated consumers who actually wanted to hear from the seller, and there was going to be clear transparency. And those lawsuits, man, they were going to go down, right? Now, they were going to go up against the people that just didn't want to follow the law. And so in the short term, there was going to be a ton of litigation this year, just a ton. I mean, I think I was expecting it to double. But in the long term, as people kind of settled into the 1-to-1 regime, TCPA, man, it was not going to be an issue. I mean, honestly, it was not going to be an issue like 3 or 4 years from now. It was going to peter out, and people were going to operate within the rules, and I was going to have to go get another job. But now that 1-to-1 is gone, I mean, this is the greatest thing that could possibly happen to me and Troutman Amin, both in the short, medium, and long term, because knuckleheads are going to be knuckleheads, right? And so when we are trying to talk to folks, I'm not talking to the knuckleheads, man. You all knuckleheads are like, oh, we're going to do whatever we want. Go. Why are you even watching this? Go do something else. You know we're not going to listen. You're going to do what you're going to do. That's fine. I don't want to talk to you. And don't call me crying later either. But the people who are smart, right, who are like, okay, wait a second. I got to make sure that my institution is protected. There's going to be even more fraud out there than ever before. There's going to be even more, consent farms and dark patterns. There's going to be more nasty tricks out there than we've ever seen before. And again, that is the byproduct of this, right? The good guys are feeling good, but the bad guys are feeling good too. It's the opposite of that old Bible verse: the rain falls on the just and the unjust alike. Well, today the money's falling on the just and the unjust alike, right? So it's a good day for everybody. But just understand, the unjust are out there, they're racing to the bottom, and you, as a lead buyer in particular, you are the one with the risk. The brands are the ones with the risk. Do not let these shady fly-by-nights hack your business. I mean, that's what this is, right? You guys, you big brands, you spend millions, in some cases more than that, on InfoSec. You spend so much money protecting your brands, protecting your organizations. You never, let data get out, and yet you're ingesting terrible, in many cases, just totally fraudulent data. In other cases, stuff that is just really, it's just not stuff that you can bet on. And that's what Pooja says. My takeaway here, is that reach has become more important than ever before. But again, as I said, I want reach to work more actively with other organizations. I want to work with IMC. I like IMC. They went out and they got something done, and I'm proud of them. And my hat's off to them. They did a great job. They deserve some applause for this. And I want to see reach and IMC have much closer relations. But at the end of the day, right, the need for standards, the need for good actors, and the need for lead buyers to take the lead and dictate that we will not buy junk, we will not buy fraud, and we will not tolerate consumers being abused on these websites. The lead buyers need to say that. They need to create a clear directive to that effect, and reach, of course, is a vehicle to get that done. And again, these things can all live together, right? IMC and lead generator organizations can operate, and they can have their sets of standards, and they can have their suggestions and modifications, and the buyer should have the same, right? From a certain perspective, there should be two organizations, right? They should work together cooperatively, somewhat adversarial, because the buyers and the sellers are going to have somewhat different interests, but they should be working together to try to find that middle ground and find what everyone can live with, and those standards that the buyers want and the sellers want, but most importantly, that are clear enough to allow people to meet the new rule, right? Here, hi, I'm the new rule. My name is clearly and unmistakably stated in a clear and conspicuous fashion, right? That is your new rule. Like if I had a little name tag, that's what it would say. Hi, my name is clearly and unmistakably stated in a clear and conspicuous fashion. That is your rule, all right? You look at your lead form, you tell me whether or not it complies with that rule. Some courts are going to look at it and say, yeah, it looks great. Other courts are going to look at it and say, get out of here, right? And that is the tension that will drive litigation now for the next 100 years. Pooja, we're going to be doing this the rest of our lives, I tell you.
Most certainly. One thing I wanted to add, those folks who have already started generating those 1-to-1 consents, my goodness, take advantage of that, right? That is a high intent lead, right? You can probably put a much higher price on it now, right?
Yeah.
And And if you have worked with lead buyer organizations and have gotten their approval and their blessing to sell them one-to-one consent leads, it begs the questions, why would you pivot away? Right? Because you may have a smaller amount of leads. However, those that have been generated, I know a lot of folks, they started back in September, started generating these one-to-one consent leads. So I encourage those folks who have been compliant, who've been following Tcpaworld, who have been listening to us preach about this FCC one-to-one consent rule for over a year now. I encourage you to take advantage of that and, come out and say, hi, I'm still selling one-to-one consent leads, and I can help you, get those higher intent leads and stay compliant. So I think that's kind of a neat thing for those folks who've already been generating those leads.
Yeah, Pooja, pivoting off to a slightly different but related topic, the new revocation rules going into effect on April 11th. What do you think? Any impact?
Oh, huge impact, right? I mean, Eric, I've always thought that ruling was bigger than the one-to-one consent ruling since it came out. And now, plaintiffs' attorneys are going to pivot back to, their traditional ways of, nitpicking on the consent forms, et cetera. But now that focus, that new avenue for plaintiffs' attorneys to kind of make their way through and make a law that's in their favor now becomes increasingly even more important than it already was, right? And
But
so,
hang on, let me stop
yeah,
you. The ruling in IMC striking down one-to-one, does that impact the revocation rule?
it does not.
Right. Yeah,
Right.
that's my assessment as well.
Absolutely does not.
Now, what's fascinating, though, is that IMC took the appeal via the Hobbs Act of one-to-one. I'm not aware of anyone having appealed the revocation rule under the Hobbs Act. And that's fascinating because without a challenge, right, it kind of does beg the question. Now, should Reach take a look about another filing? The problem is that the Trump executive order only looked at rulings that were set to go into effect within a certain window, a 60-day window. And the April 11th date is outside that 60-day window. So somebody is going to have to do something at the commission. And, Lending Tree got so mad at me. So maybe Reach isn't going to do anything this time. So maybe somebody else will have to step up and do something. I don't know. I got to talk to the board about that. I'm just being a little bit funny at the moment. But in all seriousness, April 11th is coming, and that revocation rule, which is a topic of a totally different webinar, and you're going to have to go and take a look at those of you that are following our YouTube channel. If you've already seen this, we've got a whole hour-long webinar breaking down that revocation rule, but that's still coming, at least for now. And, you're right, Pooja, like there's other avenues, to try to challenge that, but nobody's taking it. And so it's going to be really, really interesting because now you've got this whole another level of uncertainty, right?
Right.
The rule's going to go into effect. People are going to enforce it. Some courts might adopt their own evaluation of that rule and throw it out. Other courts are going to be like, no, this is fine, right? It's just one more level of, how can we take any of this seriously, frankly, because we don't have uniformity anymore. And that's what happens when you get rid of something like Chevron deference, which was so valuable, so important. Now, of course, Hobbs Act, the whole framework of FCC implementation is also under attack at the U.S. Supreme Court. So, as I keep saying, we're in revolutionary times, right? Everything is changing under our feet. Our job is to be adaptable. Our job is to be thoughtful, intelligent, and adaptable and respond to information as we receive it, which is why I tell you, when I look at the IMC analysis, I say this analysis is wrong, but I can't say that, right? That would be the viewpoint of pre-revolutionary times. This is post-revolutionary times. So now every set of analysis that we see, every data point has to be looked at through fresh eyes and say, this could be the way it is from now on. We don't know. Other courts, of course, there's inertia, right? They're going to be stuck in the past. They're going to be applying the old ways. And eventually, I think the new ways, that's what a revolution means, are going to take over. And that's what we're going to be living with. But we won't know until the stuff plays out data point by data point, which is unsurprisingly why TCPAworld.com is the hottest piece of property in America right now. And it's going to continue to be because people need to have these data points. They need to get trusted analysis. And obviously, there's only one place to go for that. Like literally, there's one place to go for that. It's funny. I started TCPA World now, what was it, like 5 years ago, 6 years ago. And I assumed that other law firms would at least try to keep up. And, there's been moments here or there where they turned on the spigot and attempted, but nobody has tried. And I don't know, maybe they just can't keep up. Maybe they just don't have the expertise. Maybe they just don't have the time. Remember that one time Troutman Pepper actually hired a blogger, like literally was hiring writers to try to write their blogs for them to try to keep up on legal issues? unbelievable stuff that goes on out there. How disruptive we've been to the legal industry is really quite amazing. But it's just never materialized. So TCPA World maintains and remains the only source of truth really on this subject matter, which is so important really to every single business in America. And we're going to keep it up, guys. We are here for you. You're here for us. You love us. We love you. This is very symbiotic. This is the way it works. And of course, if you want to hire Troutman Amin and have us defend you in litigation, you can. And Pooja, of course, is the head of compliance, and we've got the great John Henson and Angelica behind her. Always happy to help. And of course, Jen, a killer litigator down there in Florida. She's the head of the Florida office. So if you're out there in Florida, you're going to be talking with her. That's, I think, going to be the show for today. Again, very unusual format. Thanks for sticking around. Final thoughts. We'll throw it to you, Jen. What do you think?
I think it's going to be super interesting to see how the industry reacts to the one-to-one being gone. I do think that there are going to be individuals that are just going to kind of try to keep the Wild Wild West alive. And I'm hoping that doesn't happen, but the cynic inside of me tells me that that may not be so. But I do think people should be paying attention to the changes, because TCPA is not, it's here to stay. And the rules that were in effect before are still in effect. And there's new things coming with the DNC revocation rules. You need to be on top of it. There's always something going on. So just keeping your finger on the pulse so that you are compliant and you're not in a class action litigation, because otherwise you're going to wish you did.
Pooja, thoughts?
Eric, compliance remains my jam. Compliance is still important. Those folks, that are a little bit frustrated that you invested so much into this one-to-one consent, don't be, because it still matters. It's still going to keep you out of trouble. And those folks are in charge of in-house TCPA compliance. It matters even more than it did before.
Yeah, I think this is a great moment where we're going to find out a lot about people, right? We're going to find that the good guys, the people with character and integrity, are going to reveal themselves. And those that don't have those traits are going to reveal themselves too, right? It's a beautiful moment for all of us to look in the mirror and find out who we are. And I look forward to finding out who we all are. You know who I am. I'm the czar, Eric J. Troutman. Always a pleasure, and thank you so much for tuning in for this, our 30th edition of the Deserve to Win podcast. We'll see you next time. Bye, everyone.
Bye.